You probably know the feeling, sweaty, fast breathing, quick heart rate. That's a cortisol spike. It feels awful, and its imbalance is the cause of your anxiety. Rebalance Health's 3-part anxiety system helps address it at the root. Rebalance Health lozenges are natural and designed for optimal absorption, providing 24-hour relief. Live life fully without feeling like you're fighting for it. Get 50% off your first month with code CALM23 at rebalancehealth.com.
With no fees or minimums and no overdraft fees, banking with Capital One is the easiest decision in the history of decisions. Even easier than choosing to keep the Grinch away from the toy drive.
Who's going to deliver the toys to the kids?
What about me, the Grinch?
No.
Yep, even easier than that.
You steal the presents one time.
With no fees or minimums and no overdraft fees, is it even a decision? That's banking reimagined. What's in your wallet?
Terms apply. Capital One N.A. member FDIC. Copyright Dr. Seuss Enterprises. Copyright Turner Entertainment Company.
Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibiers, just wanted to hop on, do a quick recap of this Alec Murdaugh motion hearing today. It was a doozy. I thought the gloves were going to come out, but first we're going to do our song fact of the day. And the song Sweet Emotion by Aerosmith. Steven Tyler wrote this song about how frustrated he was with the band at this point. They were all doing a ton of drugs and tensions ran high, especially between Steven Tyler and guitarist Joe Perry. So the song is a statement about doing your own thing without letting others bring you down. We should be doing that every day, y'all. Just do your thing. Don't let other people bring you down. All right, let's get to this Murdaugh hearing, because I was kind of sitting here wondering if I should pop some popcorn, because it started off with like a really hostile tone. I mean, these dudes were yelling at each other, essentially. So I'm going to throw up my one graphic. By the way, speaking of graphics, I have a system now. So those of you who only listen to the audio version, in the description of every podcast, I will put a link where you can go view the pictures that you hear me talk about for the YouTubers. But yeah, so there was a lot of yelling and interrupting in the beginning. So I just made that graphic because, you know. All right. So basically, the prosecution is asking the judge to limit who can see the discovery when they hand it over to the defense, and how things like documents, crime scene photos, autopsy photos, recordings, and things of that nature will be handled. They just don't want stuff leaked. And Harpootilan says a protective order would limit who he could show evidence to. So he's not for it. He wanted his motion to compel today. And Harpootilan actually accuses the state of leaking things because he said he read something about blood spatter on a blog, which was Fitz News, who broke a story that Alec had high velocity impact spatter on his clothes, which essentially means you've got to be in close proximity when a murder takes place. So yeah, somebody's leaking something. So let's just hop into the drama real quick. So the state grand jury prosecutor, Creighton Waters, says they're here for a motions hearing on the 2 murder charges and possession of firearms during a violent crime. He says they're here for the state's motion for a protective order, which, like we said, it just limits disclosure of certain information and discovery. So Alec's lawyer, Harpootilan, comes in like a wrecking ball. I mean, he's like somebody lit a fire under him. And he says, Your Honor, we're not here for that. We're here for the defense motion to compel, and I object to the state trying to hijack these proceedings by taking over and saying that this is for a protective order. We made our motion to compel weeks before they made their motion for a protective order, and I'd ask the court to allow us to go forward with a motion to compel. By the way, the picture's on the screen. You can just see the body language. And Murdaugh, for the first time, that center picture, he looks a little evil to me. Like, look, the guy's not a good dude, but that look was a little chilling. So the state said both motions are to be heard today. He said, I think if the motion for a protective order is addressed, it makes the motion to compel moot. Because as the state has been clear from day one, we've been ready to provide this discovery. But they also think it's because of the sensitivity of the matters here, we think it's important to seek a minimally intrusive protective order so that discovery can be provided. The second is provided there's no need for a motion to compel. He also said the reason the deadline was missed was because it seemed defense attorneys appeared to agree on that protection order as late as Friday, this past Friday, but apparently they changed their mind. So Harpootilan interrupts again and says, we have a motion to compel. We filed this week after they failed to comply with Rule 5. And Rule 5 establishes time limits for disclosure by the state. He also mentions Brady, which requires prosecutors to disclose exculpatory evidence to the defense. And Harpootilan says to ignore that does a disservice to this court and the criminal justice system. So the prosecutor starts to talk and Harpootilan interrupts and just yells, I'm not done. If I can be heard without being interrupted and hijacked. So the prosecutor kind of starts yelling at Harpootilan at this point. Harpootilan says they continue to try and hide the ball in this case. I'm sorry if I appear upset, but every time we turn around, they're trying to hide something. Yeah, you appeared upset, Mr. Harpootilan, for sure. If we could have 15 minutes to address the court and call a witness, we could get it. So the prosecution says that that protective order, which started this whole issue, is the way to set the table. And he says, I would point out that Mr. Harpootilan stood up and interrupted me as I was trying to set that table. Harpootilan says, Your Honor, that table has never been set because they won't comply with Rule 5. He said they could have raised this protective order, and he says out of order 7 weeks ago and didn't do it. And the state said that's because we thought we had an agreement up until Friday. So Harpootilan yells, and if I could be allowed to finish, I know he's the head of the statewide grand jury. I know he's a very important guy, but my client has a right to a fair trial. And a fair trial means a motion to compel to find out what it is we're trying to compel. He also says, Judge, you denied a gag order saying this would be a public trial. Yet the Attorney General tries to make it a star chamber event. I would like the ability to make my argument and call one witness. So at this point, finally, the judge kind of jumps in and he's like, I'm not going to have counsel arguing back and forth or with the court. He said, before the court is a motion to compel and a motion for a protective order. Harpootilan says he'll be brief because they filed their exhaustive memorandum, and the judge says, yeah, you filed that 5 minutes before the hearing. And Harpootilan says, yeah, because we got their response late Friday and worked all weekend and couldn't file until this morning. So he says under Rule 5 and Brady, they're entitled to discovery to prepare their defense. The big question is who gets to decide what evidence they get. He said, I've been involved in hundreds of murder cases in my career, and I've never seen anything like this, which is correct. This is probably the biggest case South Carolina has ever had, ever, by far. So Harpootilan says, I would like to put one witness on the stand to explain where we are. The judge stops him and wants to know who the witness is and the need for a witness. So Harpootilan says is Captain Ryan Neal from SLED, which is the state law enforcement division. He's been in the gathering of evidence, and Harpootilan says he needs 10 minutes max to have him on the stand. So the attorney for the state says there's no need for a witness. This is about a motion to compel, a motion for a protective order. If your honor is satisfied after arguments to make a ruling, that's all we got to do today. So Harpootilan kind of backtracks and he's like, can I have 5 minutes for a witness? So the judge reads law and says a motion to compel and should the grant should the court grant that motion, the state must produce discovery. The defense does not get to interrogate a state's witness about the nature and extent of its investigation. And they talk about how the case is unique and it's unprecedented in South Carolina history. It combines violent crimes with alleged corruption of someone's law license on a scale that's never been seen before. A protective order is necessary in this case due to the intense media interest. Everything will come out in the open. All this is meant to do is have it come out when it's supposed to, and that's in the courtroom. That's what the state said. Harpootilan says they want to hire their own experts to review GPS data from cell phones, Alec's truck, along with forensic evidence such as autopsies, time of death. He also mentioned DNA testing and blood that may or may not show if Alec fired one of the two guns that was used to murder Paul and Maggie. And also, if you remember, Fitz News did say a source told them that there was high velocity impact spatter on Alec's shirt. And that just means that he had to have been in close proximity, or somebody wearing his shirt had to be in very close proximity when at least one of the murders took place. So Judge Newman ultimately said this is a case that cries out for the issuance of a protective order, not a blanket protective order, but one that addresses the issue most relevant in this instance. So he ordered search warrant materials, including the support affidavits, to be unsealed. The protective order will not include information independently discovered or restrict either the state or the defense from addressing information already in the public domain, which is kind of a lot as far as unnamed sources go. So a lot of people have asked me about the death penalty in South Carolina, and at what point does the state have to say they intend to seek it? Well, in South Carolina, when the solicitor seeks the death penalty, he shall notify the defense attorney of his intention to seek such penalty at least 30 days prior to the start of the trial. So they've got time. Not sure this is going to happen in January, but dude, I'm going to tell you right now, those two, go watch the first 15 minutes. It is, I don't want to say it's funny because we're dealing with heavy stuff here, but look, guys, sometimes you got to laugh. You know, you got to laugh at these attorneys yelling at each other like they're, you know, in middle school. And you know, it's just, yeah, this is serious stuff. I never will laugh at a victim's family, or anything having to do with someone personally. But man, these two guys, they were ready to duke it out today. I thought Harpootilan was the one that kind of was the aggressor and constantly interrupting and yelling. And the people in the back, like in the gallery, were like, you know, you could just see they were like, oh my gosh. All right, guys. So that's kind of what happened. It was like a 45-minute hearing. I didn't want to go verbatim just because it was a lot of back and forth. Just wanted to hit the important parts for you. Tomorrow, new episode in the Vallow Daybell mega series. As we know, if you have not heard, the George Wagner trial has been delayed until September 6th for openings. They are finalizing jury stuff this week. And once that jury is finalized, they are taking them on a little looky-loo, a field trip to go see all of the trailers where the massacres took place. These things have, other than being moved from their location to this impound lot, which wasn't watched for a day or two, there's a whole lot of stuff around that. But these trailers have not been cleaned or really touched. So I think it is a powerful start to this case for those jury members to see the blood spatter. And some of these victims were shot 5 times in the face. And so it's not going to be pleasant. But so we have all week to do other stuff. So I think we're going to keep on keeping on with Vallow Daybell, keep our eye out for anything new in these other cases. In the meantime, appreciate you guys. All our new listeners, just want to give a big fat welcome to you guys. I mean, really, I'm blown away with how many people are joining us, and appreciate our old listeners who have stayed and supported me and the podcast, with Fruit Loop moving on to do her mission work. I have felt the love, and you guys just don't know how much it means to me personally. So thank you. I'm out. I'm going night. See you soon.
You probably know the feeling. Sweaty, fast breathing, quick heart rate. That's a cortisol spike. It feels awful, and its imbalance is the cause of your anxiety. Rebalance Health's 3-part anxiety system helps address it at the root. Rebalance Health lozenges are natural and designed for optimal absorption, providing 24-hour relief. Live life fully without feeling like you're fighting for it. Get 50% off your first month with code CALM23 at rebalancehealth.com.
Judy was boring.
Hello.
Then Judy discovered ChumbaCasino.com.
It's my little escape.
Now Judy's the life of the party.
Oh, baby, mama's bringing home the bacon.
Whoa, take it easy, Judy. The Chumba life is for everybody. So go to ChumbaCasino.com and play over 100 casino-style games. Join today and play for free for your chance to redeem some serious prizes. ChumbaCasino.com. No purchase necessary. Void where prohibited by law. 18+ terms and conditions apply. See website for details.